To be mentioned.
Lord, may I have your lordship kind leave to mention, my lord, I'm seeking leave to file without the certified copy. 22nd order has been passed, 22nd of September. I have applied for certified copy. Without the certified copy, I praying for filing of this appeal.
But how can you move?
There is an urgency because, my lord, this is regarding this upper primary. Now, this petitioner was allowed to participate in the upper primary. He could not. He made an application for
Don't know
no.
tomorrow
Kindly,
whether
yeah, no, no. Today is the last day for this panel is expiring. My lord, kindly appreciate. My lord, I recommendation I applied for beyond 90 days, but within 150
Yeah,
days.
leave granted.
My lord,
Yes,
kindly
got
fix
it.
it today at 2 p.m. My lord. Otherwise,
Sorry.
or tomorrow at least, my lord. Otherwise, it will become infructuous. Because your lordship knows that 150 days. I'm grateful to lord.
It may be permitted to mention one matter. I'm appearing on behalf of Mr. Ratul Das, who was appointed a receiver in one of the matters currently before your lordship's bench. He had mentioned on Monday, your lordship had asked to mention him. Currently, he's in difficulty, so I'm mentioning on his behalf. I was requesting only if the matter could be kept on the list, because in his duty as a receiver, he has seen certain.
Already in the list. Is it not in the list?
I suppose, my lords, I'm instructed not, because it was not made returnable. The last order wherein he was appointed.
We had asked him to give notice to all the parties.
Yes, my lords, that we had given also last. This is the hard copy. Last night, I'm instructed he had also emailed to the parties.
The
But
parties are here.
the only issue is, my lord, there's some security breach with regard to the premises where regard to which
It is assigned to us. Matter is assigned to us.
No, my lords, I'm instructed that by way of the determination, since it's a contempt appeal.
Oh, it's a contempt appeal?
Yes, my lords. The last order was passed by Justice Joymal Bakshi and Gaurang Kant, wherein he was appointed.
What was said? What was said in that?
In that order, it was said that Mr. Das is to visit the premises every fortnight and check that no clinical establishment is running.
Now, what is his prayer now?
His prayer is that when he went to visit the premises last week of August, he saw that portions of the premises have been demolished, broken. So it is not within his capacity to.
এটাকে লিস্টে দিয়ে দেবেন অ্যাপ্লিকেশন থেকে। হ্যাঁ হ্যাঁ it's an
original side matters.
ওটা পার্টিকুলারসটা নিয়ে নাও, ওকে বলে দেবে যেদিনকে ভেকেশনের পরে বসবো অরিজিনাল সাইডের দিন সেদিনকে দিয়ে অর্ডার করে দেবে। Yes, call the list.
Item number 1.
Yes, we called you because when we went to sign the order, Mr. Panda was
My lord, I personally requested the CWC. She is present, my lord.
present. CWC. Madam, what is the problem?
মে আই স্পিক ইন বেঙ্গলি?
বলুন।
ব্যাপারটা হচ্ছে যে পুলিশ আমাদের কাছে বাচ্চাটিকে যখন নিয়ে আসে তখন আমাদেরকে বলা হয়েছিল যে বাচ্চাটাকে ওর বায়োলজিক্যাল মা বিক্রি করে দিয়েছে এবং সেটা 100 টাকার বিনিময়। একটা স্ট্যাম্প পেপার আছে, তাতে টাকার কথাটা লেখা নেই, কিন্তু বাচ্চাটিকে
Put off the mic.
Yes, not under me, but it is under সা লিলুয়া সা হোম, কারণ বাচ্চাটি রিজার্ভ হয়ে গেছে, কিন্তু কিছু টেকনিক্যাল প্রবলেমে এখনো অ্যাডপশনে বেরোয়নি, বাট হি ওয়াজ রিজার্ভড।
No, we will look into the matter, but in the meantime, if adoption procedure is completed,
Adoption procedure is completed, sir.
but he has not been given to hand
Not
it
been
over.
given to his adopted parent due to some technical problem. কারণ ওকে
No, if that issue may be resolved, but before that, if the child is given to some other couple, then the mother's claim will stand frustrated. no?
তাহলে স্যার একটা আমাদের স্টে অর্ডার লাগবে, তাহলে ওকে আমরা
Yes, we shall say that, but you have not been made a party to this. So we will ask him to make him CWC a party, and Mr. Panda can appear on behalf of CWC. There is no problem. You furnish the instruction
Sir,
and till the return,
শুনে নিন আগে।
and till we hear the matter, don't hand over the child for the adoption.
I have asked her also that.
Huh?
Since the matter is pending, do not hand over right now. Let it be after final decision. But if there is a stay to that effect, my lord, then it becomes easier for her also.
What stay, what stay?
That
They-
they will not give in adoption because it has already been made legally free for adoption, free for adoption. So it is up
He
to that
was
stage.
declared legally free for
The
adoption
adoptive parents are
for
there. So
or 2 months before. এবং মাইনাস অ্যাডপটিভ মানে তাকে ইলিগালি দেওয়া
Item number 2.
Two, I beg to appear on behalf of the appellant.
there is any government notification or circular permitting the widow to exercise option or to refund the money. Malat, I have the instruction, there is no such government order. Though, Malat, however, in similar circumstances, coordinate benches have already passed some orders, Malat, and the authority have complied, Malat, in similar situations, directing the widow to refund the money with interest, and thereafter pension was.
But how will she calculate what is the
Malat, this calculation will be made by the DI. They will have.
you obtain that instruction and put into lines.
Your lordship pass an order, DI will calculate and submit it. Malat, this is the usual process, my lord. With the order, if they approach the DI shall calculate and it will give it to the concerned person and he
You
will
are
deposit.
sure?
Yes, my lord, yes.
Mr. Body, what is the, because if we dispose of, we will be recording your contention upon instruction. We don't want to embarrass you. We don't want to embarrass you.
With affidavit. Then tomorrow I shall affirm this affidavit.
Hmm?
By tomorrow I shall affirm this
We
affidavit.
keep it on the reopening date.
Very good, my lord. By tomorrow I shall
An
affirm.
opposition.
Yes, my lord. Tomorrow I shall affirm.
Give to, so you also, the DI will be approached, the calculation also it can be made. You can incorporate it in the affidavit so that we will direct you refund it within such and such, and the consequential
If I,
benefit.
my lord, then if the calculation is required, then take
1
some
week
time.
after vacation you give it.
Very good.
Mr. Badi Learned Advocate appearing for this.
Item number 3, my lord, I am for the petition have been laid by Mr. Sudipto Dasgupta.
Led by
Mr. Sudipto Dasgupta. Mr.
very,
Sudipto
very Sudip.
My lord, he is engaged in a matter in courtroom number 6, my lord. My lord, on the last occasion, my lord, your lordship had directed, my lord, my senior had handed over your lordship's 4 schools, my lord, where petitioners
But there is any vacancy or not?
there vacancy.
You
or
are
not, my
in
lord.
my right.
Pursuant to Justice Sen's direction.
Yes. Uttar Dinajpur, pursuant to your lordship's direction, I have received the instruction, there is no such vacancy.
It is
You have tried on an earlier occasion, my lord. One vacancy is there, there is no student, stream is totally closed. Mr. Sengupta, in his own from the pocket, he has given the names.
Mr.
Mr. Rajgupta.
Dasgupta.
What is the main matter about?
Well, he has the he is working in Kuch Bihar. Now he is one to Uttar Dinajpur.
No, he's working teacher.
Yes, yes. Dinajpur.
My lord, kindly pass over the matter, my lord. My senior will be here in 10 minutes, my lord.
Lord, let it be after vacation.
Let it be after vacation.
Only well, in the appeal or petition, he has not mentioned any vacancy. Subsequently, last occasion, my lord,
We understand that. Tell Mr. Dasgupta we will take it up 1 week after the vacation.
Well,
In
you
the
will keep-
meantime,
you kept in the record.
My lord, I have. My lord, my senior is coming on the way. My lord, kindly raise it today on.
what is the problem? I don't understand.
Ajmer, well, he is coming.
Sorry to copy that. My lord, subject to consideration, my lord. My lord,
Wait for your senior. We are waiting for your senior. Where is he? He's coming or he's somewhere else.
my lord, he's engaged, my lord. My lord, kindly please. My lord, I'm very sorry, my lord.
So, can coming with the This list was
Mr.
handed over on the last.
Mr. Chattopadhyay, learned AGP over.
I appear for the appellant.
I am for the respondent number 1,
Writ petitioner.
2 and 4.
And I am the appellant, private respondent. Headmaster.
Headmaster.
But yes, kindly seize the order. My lord. The board has been directed to initiate departmental proceeding against me.
Page 158. Last paragraph.
What years? 58 of
158.
58 of this 158 of the stay application. The-
158. Is order starts from 150.
Hmm.
20th of May 2020.
Yes.
What the guardians?
Guardian and the member of the
Managing.
managing committee.
First of all, my lord, they are not the guardians. Your lordship takes up the writ petition, their averment at paragraph, how they have described themselves. The writ petition starts from page 20. Nothing.
Order of this honorable court, my lord, we have asked the GI to hold the police in the inquiry and file a report. Accepting private lordship, we have asked it. Upon this, fine, then my lord focus will begin. Proceeding will be initiated. As per
It has not yet
not
been.
But I am absolutely on a different point. First of all, my lord, your lordship takes up the locus standi point, whether the writ petition is at all maintainable. What they have asked for. My lord, kindly turns to the affidavit in opposition which I have filed. But kindly turn to page 102 once, then 102. Page 103. 1C. I have described how who are the petitioners. Petitioner number 1 was a teacher. 103. 1C paragraph. Of the school. Petitioner number 2 is the present teacher of the school. The other two petitioners, Rakib Hossain and Chittaranjan, are not connected to the school. How they can maintain a writ petition against the headmaster, against the internal affair of the school?
What do you say about the 3-member committee?
But I will come to that. I will, yes. But I am absolutely on a preliminary point of locus standi.
By the learned senior.
That is why, I have come to this court. But your lordship kindly sees, but I want to place a division bench judgment, a very recent judgment of this court. But presided over by Justice Shobhoshachi Bhattacharya. This is a single bench judgment, but the court has taken care of all the judgments. Kindly have a look. Paragraph 22, 23.
You don't want the inquiry to proceed?
No, not at all. But I am absolutely on a different point. I am on the point of locus standi. Whether the petition
is not maintainable. At this juncture, you are saying that don't proceed against.
But
proceeded on the basis of one writ petition filed. Both when perusing the records found that there was a 3-member committee report. There are enough instances of misappropriation. Why you are afraid of facing?
I tell you, lordship.
Even if your locus standi point will hold in your favor, then the writ petition is not maintainable. This order, then you come get within there. But from the order we find that there are serious allegations, Mr. Bhattacharya. There is a 3-member committee report, and in appeal, we are sitting as an appellate. We cannot sit as an appellate authority over the order.
No. But may I reply to this? May I? But on 2 points. First of all, Malad, whether the
there is no urgency. Either you, if you have finally here.
Yes.
Without any order, but this injunction at this stage we are not.
Malad, I have a little prayer before your lordship. Malad, your lordship has heard this matter at length. Now the question of maintainability of the writ petition, that was first. And the second point is, kindly sees the penultimate paragraph, which my learned friend has mentioned at page 158.
Come to page 151.
Yes.
Allegation against you.
Malad, the allegation, I have seen. The allegation is.
You want us to stop the inquiry?
No, not at all. Malad, the inquiry was proceeded. The DI 6 years back sent the matter to the board for taking action. Board kept mum.
Now the board will act.
No.
You will be given an opportunity of
Malad, I tell your lordship. Malad, what I am on is whether the board has the power to comply this portion of the order. Page 158. Kindly have a look. Kindly see the rules. Disciplinary rules 2018. Kindly takes up page 158. Allegation of 40,000, misappropriation of 40,000 rupees. I will pay from my own pocket. That is not the issue. Issue is something else. But kindly turn to page 158, last paragraph. Therefore, based on the foregoing discussion, this writ petition is disposed of with the direction to the president of the board to take appropriate steps to ensure that proper inquiry is conducted by a competent authority or authorities to determine whether any substance to the allegation raised against the headmaster regarding the misappropriation of fund allocated to the school under various programs. Then, if the allegations are found to have merit, appropriate action shall be taken in accordance with law. Now your lordship kindly see is the power or duty of the board. Rule 3. Does the board has the power? Kindly have a look. And then rule 5.1. Sees the power of the board. দিদি একটু পাবো ওটা এটা দিয়েছি বোধ
Yes, what you are showing.
মানে rule 3. It said to appoint headmaster to issue confirmation order in respect of service of the headmaster assistant teachers, to give effect to the recommendation of transfer, then to take disciplinary action against misconduct of teaching and non-teaching staff, to collect vacancy report from the commission, to maintain as appointing authority reservation roster of the post. Now, but the disciplinary action against the misconduct of teacher, that is, the board has the power. Now your lordship kindly sees the direction of the court.
What has been exactly said, page 158, which you have.
Yes, it said
that appropriate steps will be taken to conducted by a competitor. After that comes, then the board will issue a show cause.
True. Malad, I replied to the DI. DI sought for a show cause. Malad, reply from me by issuing a show cause notice. Malad, I have replied to the DI. To the DI. Now, what has happened is, what is the outcome? And I was not given. Yes, I'll return in 2026.
2026.
Yes, kindly see the observation of the DI, page 124, which I have against my reply of show cause. Start from 123, 3rd of February 2020.
Yes.
Explanation of the headmaster of so-and-so, reply, then 24. In view of the above, his reply is not found satisfactory, and hence, as per rule, for taking disciplinary step against him, necessary proposal is to be sent to the board in terms of the notification so-and-so. But before doing that, a final opportunity is given to him to further explain the matter relating to misappropriation of fund of so-and-so and others, as observed by the investigating committee, while reported at 2019, communicated to him by the officer so-and-so. This is to remind him that he must have to circumspect to the queries asked for and not to cross his jurisdiction at any step, and must have enclosed necessary document in support of his claim so-and-so. But this I have given.
This was in 2020.
20. Well, no final decision. Yes, I have done everything. Now,
Now that considered the like
kindly pass that order. A matter cannot be directly sent to the. No.
May I? The rule 5.
yes.
Now, the case is the DI said yes, there is a gross misconduct on your part, there is a misappropriation, but before sending the matter to the board, I am once again calling you to explain. Now, I went there. I explained my defense.
Where is your reply?
Kindly cease.
That was passed.
No, that is my case. Now, the DI will pass the order that we are, after the scope was given to you, we are not being satisfied by your reply and your conduct, so we are sending it to the board. No. DI did not do so.
Yes, now the DI will do.
Yes, kindly pass that because but the DI without doing so sent the matter to the board for taking action against me. It was in 2020. Yes, yes, they had done so. Kindly allow me to complete. Then Mrs. Bhattacharya will kindly. Then your lordship kindly sees what the DI has done. This is in 2020, and this is the part of the writ petition. Now your lordship kindly sees what?
Again a complaint.
Just a second.
Participate 130.
134. No, thereafter no complaint. This is the I wanted to show, place it before your lordship. This is page 134, 27th of November 2024. Allegation raised against me. 4 allegations: mass petition, 3-man inquiry report. Then you are requested to take step to look into the matter seriously to search out the previous MC resolution to ascertain as to whether appropriate steps was taken by the MC of the school for the purpose of taking disciplinary action against the concerned headmaster. If appropriate steps has not been taken, the managing committee till date, you were requested to take urgent steps. This has been sent to the president. The president was not there. The post was vacant. Now, what has happened is, your lordship kindly sees the next page, 135. Same thing. It was sent on 27th of November 2024. The second notice was sent to 27th of February 25. You are requested to take action against me as per the notification rule 2018. Kyle tells you the next page, 136. The president is writing a letter to the DI.
Yes, what you want to show?
The president said that I have taken charge in 2021, and since then nothing has been found regarding this the matter. Therefore, it would be my audacity to take any action against the sub judice matter because writ petition was pending. The writ
Was of
2019, they filed it against me. Now,
passed this order. DI passed the order on 3rd of February 2020.
2021 order.
That was pursuant to an order of the court.
No. That was on the 3 members committee report.
On that date, the writ petition was pending.
Yes.
So what writ petition was filed? That's it.
This writ petition which I have just shown to your lordship. Only one petition is against me. Then your lordship will see is the next page. Page 136, my lord, I have shown to your lordship. 137. The president is once again writing. In 2025 to the DI. One writ petition being so and so is pending before the Honorable High Court on identical issue, and hearing the same is fixed on so and so. The state is also a party to those proceedings. So at this stage, I could not make any decision on this issue, and writing for the I'm waiting for the order of the High Court. So the explanation sought by the DI from the president, that was never given. Kindly sees till 3rd of March. 4th of March 2025. That was not given to the DI. Now,
DI will now take step.
Now,
if no reply is given, DI will pass an order in your favor.
Number
You are wanting the appeal court to go in there.
yes. Number if the DI passes an order, which but I went to the DI office, I explained my conduct for the second time. How the DI can send the matter to the board?
Authorities cannot take any step because it is a stale claim now.
No, the authority can, but the authority's decision is contradictory. One decision kindly says, but what the why the but I request your lordship to see the order request of the letter of the DI once again. First is 134. 134.
120. You are banking on this. But by this order, DI was not found satisfactory. But the DI said, but before taking a final, before doing that, that means before sending the proposal to the board, have to be given a final opportunity to further explain the matter with respect of such and such.
That I have done. But if thereafter, but the resulting.
We have done that. We will direct on, since they have also sent it to the DI will consider that.
Where is the, yes, absolutely. I'm absolutely on this. But why the question of sending the matter to the board comes?
After the DI, upon hearing you, what she says, DI will take a decision, you will get an opportunity.
I will.
Now the DI will send a proposal now to the board.
Yes, but that has been done before completion of all the process. That is my case.
Nothing has done. Board was a total silent spectator.
But DI for the second time send the matter to the board.
No, not to the board, to the president.
No, to the board also. Kindly see the second notice to the board.
Admitting that, Mr. Bhattacharyya. You cannot stall.
I am not on that, but absolutely before the appeal court, but I have come on a very short point. Well, board, the matter has not been finalized in the office of the DI. So how the matter can be sent to the board? Asked you.
Yeah, that is the procedure laid down.
Yes, but it has to be completed at the office of the DI first, then it will be sent to the board.
What you are saying?
What is rule 5? Well, first,
You tell us about 124.
Has been sent to the board. Well, the board has done nothing.
The board. Yes, this was there. The
Head of the institution and coming forward.
So he did not take any step. So to this they have filed. Now you have, in terms of the order, you have issued it.
You can ask the DI to hold a preliminary inquiry. That paper I don't have, your lordship. That is as per the rules. What I'm showing you, that was the rules. He is taking 2 points on paper. So you are not having that. We have asked the DI to hold a preliminary inquiry and submit a report before us. And after going to the report, if it is found not satisfactory, then we will issue a show cause. That is the order of the court. After the inquiry report comes to us, that's the preliminary inquiry. And issue one more thing, your lordship. Board, what is submitting that board, the school only on basis of the report of the DI cannot act, your lordship, because there was no formal information to complaint laws of the court. That's sufficient given on the previous. Well, rule 5 is the proceeding, how the proceeding is to be made. And rule 5 is
What was it, sir? No formal proposal.
no said report by the board. That is what rule 6 says, your lordship.
No, not by the school authority. The submission is after this 2024. After repeated reminders of the DI to the school, records were not recorded, nothing was done. So now he says that my representation is lying pending unless it goes from the DI has to take a decision on that. Prior to that, board cannot do anything.
No, that I say. Here I join the issue. Rule 5 sub-rule 12 says, sub-rule 12, that is page 143, your lordship.
Yes.
Sub-rule 12 of 25. The board may sue over the issue.
Yeah. Rule 5.
Sub-rule. Lordship, got it?
Yes.
The board may sue over the issue. If there is a written that any misconduct has been committed by a teaching or non-teaching staff. In all cases of so-called proceeding, a preliminary investigation has to be conducted.
So you have applied this provision.
We have, as because there is direction in the court, we have issued a notice to the DI to hold a preliminary inquiry. So well, even what is submitting that he is pending before DI, how can DI send, or if after completing DI will send? Where is the power of the board? So well, this is the power of the board. Even if we get one letter and we find that something is there, we must proceeding is to be initiated. Board has the power to issue suo motu procedure. So well, only because what he was showing that DI has given an opportunity of hearing.
No, we didn't follow. He showed us rule 3 that you have a right, the board has a power to take disciplinary action.
But then rule 5, how? Where is the right to file disciplinary proceeding?
143 of the writ petition.
142 of his application.
43. Same, 143. I have annexed the rule. 40, actually starts. Rule 512.
142.
No, 142. Right. The any officer not within the rank of a sub-inspector of a school conduct preliminary investigation or not staff upon receipt of a complaint pertaining to misconduct of a teacher or staff from the committee or the administrator or head of an institution. So, here there is no formal complaint from the committee or head of the institution because the petitioner applicant himself is the headmaster of the school. Now, Your Lordship, what my learned friend was submitting that first DI took cognizance of the matter, DI have gone through it, DI decided to forward to the board, but there was a line that before forwarding, DI will give another opportunity to the petitioner, and that was given to him, but there is no formal order from his side. That is as 2020. Thereafter, 2024, the DI wrote a letter to the president of the school and also forwarded the same to the board. So, there was an
final opportunity to be given to explain the matter before the headmaster. Let us read. Appropriation observed by investigator communicated by. But before doing that, a final opportunity is given to him to further explain the matter. So, this explanation will be given to whom?
That is of 2020.
Right.
Now, Your Lordship, that explanation is to be, as per what I understand, this explanation school has to give and the applicant has to give to the DI. Now, he is saying that he has explained, but there is no formal order thereafter from the DI. So, we don't know.
The DI did not say that this is to remind him that he must have circumspect and not to cross object. This direction is upon whom? Upon the head of the institution.
Now, the head of the institution has several letters. My learned showed that as the matter is sub judice, they said that we cannot do anything as the matter is sub judice. So they refrained themselves from taking any steps. Now, Your Lordship, the matter came up before the board, on the trial judge, Your Lordship, directed board to proceed if to hold an inquiry, and if it is found anything against the person, then we have to proceed. So, accordingly, my lord, using our power, we have pulled it.
Sometimes, my
You are not being able to show us that letter, na, by which it was sent to the DI. What is there?
Proceeding has not yet been initiated. You know, proceeding initiates from issuance of charge.
We are not on that. He has said that DI kept the matter pending. School did not grant any opportunity of getting. Now, when the DI has been asked to give a report to you, that time the petitioner will be entitled to the DI would be under obligation.
The rule is that we will hold a preliminary inquiry as far as own and forward it to the court. What if finds then issue show cause, then the petitioner will get a chance to reply with the show cause.
Ms.
Then
Bhattacharya, your case is you are coming under 512.
Rule 5.
No,
Rule 5.
no, 512. 512 is,
As because the order of the court.
no, no.
And then
You have issued a letter to the DI under which provision?
and one.
We want to know under which provision. We want to know under which provision.
That is a
When it is under 5.
512. 512. You see,
Only rule 5. Only rule 5.
sorry, see,
Because well, there's an order of the court. If it was not an order of the court,
brother is asking you a question that under Rule 5, which provision you have sent? You are saying we have sent it by High Court order.
no, and it will be rule 5-1.
What is your stand there? Rule 5 is an order of the 5
No,
one
Miss-
is a general.
Ms. Bhattacharya, we are trying to understand. An initiation of a preliminary inquiry by the DI on a direction from the board, does it tantamount to initiation of disciplinary proceeding?
No. Here the order is that board has been given direction to hold an inquiry to the competent authority, and after producing that inquiry, if court finds that there is something, then you proceed. Then you proceed.
When did you issue first? Sorry, that letter to DI when did you issue? The hard is not done the advocate appearing for example. This Coeli got
No, I'm for the appellant.
Item 5.
On the last occasion, my lord, there was on the last occasion the leave was granted, my lord, for on the last occasion the leave was granted for necessary party
Oh,
application. Necessary party.
Have you served upon Hadoop?
Yes, my lord. I am for the appellant, my lord. Always. Farooq. This is service. Service.
Who are you?
I am for the appellant.
আরে নামটা বলুন।
Farooq Malik. Yes, my lord, Farooq Malik.
Just place the order how Hadoop is prejudiced by this order.
Yes, my lord.
Hadoop
There
has preferred the gift to appeal
read
against an order of 14 July 2021. Satisfy us, why do you want the leave?
leave, my lord. There are 3 read petition, my lord.
Respondent number one is allowing necessary article respondent number 1 by this court. Section 5 করেছে।
My read petition.
You filed an addition of party application.
Not addition, my lord. It was added. It was added as a respondent number 1.
He has
My lord,
already
the appellant herein, he was not a party in the red petition.
He thought he would make a leave to appeal
No.
application.
My lord, he has not made that.
He has not made that. He's seeking
Yes.
addition of respondent number 1.
My lord. He was not a party in the red petition. There is an order by the honorable single judge in respect of which there may be a chances that he gets affected, his appointment. That's why he has preferred this appeal.
appeal application.
Yes, my lord, that has to be
Sorry,
done.
which is
Leave to appeal করেছেন, my lord? জিজ্ঞেস করছি।
Application. I have filed this.
Leave to appeal এর application file করেছেন? বলুন, my lord।
where is the
করেছে?
two appeal
Section 5.
can prove
Can't prove, my lord.
can state for necessary party.
My lord.
Addition of purpose of access from number 1.
Application for application for understanding by the application for necessary eligibility.
It leaves
Application for necessary party.
Was not even a party.
respondent number 1.
দিয়েছে আমাদের copy। আর তুমি আমাদের কপি দিয়েছো কেন?
Can't
To explain this to him, we have already explained. He's not. Maybe
My lord, my lord,
that he has to file.
An
We told
application.
him on the last occasion. He
Yes.
said that yes, I do. Maybe he's not.
my lord, I understand. My lord, after vacation.
Yes, my lord. There is a difficulties, my lord, on the last order.
We are in a difficult.
Application for leave to appeal file করতে that হবে না বাবু। My lord, you have both the body after vacation. My lord, after vacation. Whether the petitioner has been served or not, I don't. A petition. Number 6.
Like
24th October.
24th of. Yes, next.
Item number 7.
7, who is there? After vacation. Yes. Given it কোনো order ছিল নাকি?
Lagi apa? Apa itu? Art. Compilation বানিয়ে দিলাম।
States happy.
Time for the respondent.
Respondent that Acharya. Who is the appellant?
Sanjeev Das, my lord.
কোথায় গেছে? After vacation.
No, my lord, kindly record, my lord, I am praying your lordship's kind leave to file a supplementary affidavit.
সেটা তো দিয়ে বলেই দিয়েছে।
No, that was
You are the read petitioner.
read petitioner.
Have they filed a supplementary? Have they filed a supplementary?
Yes.
Now what supplementary you want?
Now, last occasion, your lordship wanted to know, my lord, whether I approach before the authority for getting higher scale of pay earlier than that of the read petition.
That supplementary.
Well, I have used a supplementary affidavit.
Mr. Das, for the state wanted to file a supplement.
That he has given.
So to that you use an opposition. So it is that
Higher scale, yes.
that this is
No, this is not that.
what you are saying, Mr. Acharya.
My lord, I am submitting one supplementary affidavit annexing a document that I have earlier approached the authority for granting a higher scale of pay. The school has been forward. School was forwarded this claim. Supplementary কি দিয়েছে?
ওরা তো ওই আগের opposition reply-টা trial করতে দিয়েছে।
My lord, only the reply and opposition that has been annexed in the supplement.
Was not there in the
No, read petition in appeal. There is the application that was not there. That is why your lordship granted leave to file. My lord,
order 41 rule 27. With the
no, he can bow down before your lordship. We also bow down before your lordship.
He's very happy.
Yes.
Another thing I want to point it out, if you lordship will permit me. Last occasion,
Mr. Acharya, which document you want to place?
দেখি।
You have that document?
Yes.
Now,
left hand side.
The page 4.
Mr. Acharya learned advocate appearing for the writ petitioner respondent number 1 has placed a document on record by way of a supplementary. Let the same be kept on record. A copy
Eight I appear for the applicant.
But I am appearing for the.
Last petition state said that they will file a report today.
I'm ready with the report. Sure. Give it.
Of time. And 5. Allowed. 24.
Yes.
Lord, in the month of April, my lord, it was directed from this honorable court to file report.
Month of June.
Month of June, sorry. Month of
Okay,
June.
kindly have a look at 30th June 2025 order.
Month of June.
30th June 2025 order, the last page, paragraph 6. We request the Principal Secretary Finance Department who is present in court to decide the issue within 8 weeks from date and file a report in the form of an affidavit on the next date of hearing.
Lordship regarding
Paragraph 6, internal page 3 of the order. 30th June 2025 order.
Paragraph 6, you said.
Paragraph 6.
Now, where is the direction for report? Which paragraph?
Paragraph 6. We request the Principal Secretary Finance Department who is present in court to decide the issue.
What is the order date?
30th June.
30th June.
30th June 2025.
Paragraph 6.
6. We request the Principal Secretary Finance Department who is present in.
That report has been brought today.
Yes.
Now,
Yes,
what
Your
was the order 1st May? Oh, this is subsequent.
Yes.
You have given the report. You
I have
will
given,
submit to-
I have given a copy to him, your lordship. I have also.
Section 5 allow Mr. Seth,
I'm apprising.
satisfied with this?
I'm apprising. Your Lordship.
Item number 9.
Item number 9, my lord, I'm appearing in view of the appellant, my lord. Service, my lord, has not yet been completed, my lord.
Subdivision.
It-
Item number 10. Prince. For the petitioner, my lord, the untainted teacher, he lost his job. My lord, the petitioner participated in the both selection process. My lord, the 19 and my lord, the upper primary selection process. And both selection process, petitioner empanel and successfully, my lord, the got the recommendation letter. My lord, the petitioner at the time of my lord, the issuing the recommendation letter, petitioner was in the service in the 19 school. That's why my lord, the petitioner not joined in the my lord, the upper primary school. But in terms of the order passed by the Honorable Supreme Court, in paragraph 47 in the judgment dated 3rd April 2025, considering the paragraph 47, the petitioner made application before the School Service Commission. My lord, we lost the job, so that my lord, kindly allow me to join in my previous job. Well, they have not considered representation pending. I move an application before my lord, the writ petition. But the Honorable single judge, my lord, was pleased to my lord, dismiss the writ application on the ground. My lord, the petitioner is not entitled to get this benefit. My lord, they pass the order on the ground that my lord, the panel is expired. Well, my contention is that my lord, panel of the upper primary selection process for physical education, work education.
That is included within our judgment.
No, that is my lord, the another issue. Justice Musmi Bhattacharya order. Monitoring that order, my lord, the selection process still is going on because on that ground, upper primary, my lord, my lord, observed that the panel is expired for the empanel candidate, not for the wait-listed candidate. Well, is the panel is not the published, entire panel would be expired in the 1 year, or my lord, till the panel is valid, because my lord, the government of West Bengal, my lord, issued the notification, my lord, in the by creating some supernumerary post. That matter was challenged pending before the single bench. That panel has been extension, the matter fixed in the month of November. That's why this selection process is still is continuing.
Plus, are you a person meeting the upper primary judgment which we delivered?
No, that is this is except physical education, work education. That is the another.
That this is a
Separate issues. That is recommendation letter is issued in favor of the petitioner, but a similar circumstance that time she was in service, so that not joined that school.
Then how can now they have their 2016 physical education again they have started?
Now this panel is pending because Malad no, Malad, I have the document 2022 have they issued the recommendation letter.
Let us go through.
Kindly see Malad the impugned order, Malad.
Just give us 2 minutes.
No, December, I am in the service because it's a temporary service that will be expired.
That will expire you are already.
Yes, yes, in service. Malad, that is only temporary. Malad, in December it will be expired.
How can
Malad, because Malad, subject to lordship correction in Supreme Court, Malad, the Honorable Supreme Court in paragraph 47, they have stated Malad, if they lost their job, they have Malad, they apply before the in previous service. While
That is in service, the persons who.
Malad, that is on this ground, Malad, on this ground, several repetition was moved. And my lord, single bench, was pleased to direct to allow in the selection process and counseling process. They have joined, but in that case, they not allow in the selection. They have already, along with the recommendation letter, that post is still vacant, and that selection like to bolte din na,
That is not with respect of work education, physical education.
Already put it is already expired. It's gone.
Malad, kindly see page 143, Malad. This is on the, that's why Malad, I come before Malad, your lordship, Malad, 143, Malad, this is the created post of the supermarium. Yes. এগ্রিমেন্ট অর্ডার হয়েছে তো একটা দাদা কিসে এই ম্যাটারে হ্যাঁ এই তো এটাই তো পুরো দিন কি আছে
অ্যাপ্লিকেশন এটা তো ওয়ার্ক এডুকেশন ফিজিক্যাল এডুকেশন না
সেম সিলেকশন প্রসেস
না ওয়ার্ক এডুকেশন আলাদা
এটা কিসে
তুই তো নিজে তো এটা আজকে আপার প্রাইমারিতে দেখা
because Malad, the panel is still not expired. But kindly no, this is the document. Kindly see, my lord, honorable single bench was said, Malad, the panel is expired on. Kindly see page 141, paragraph 5. Second volume, Malad. Last portion.
Ordered your reading.
Yes, but this is the stated model 11.
Petitioner is not a waitlisted candidate.
No. Petitioner is not the waitlist. Petitioner is impanel candidate. My lord is saying that the panel valid for waitlisted candidate. But panel is valid for each and every. Panel means impanel and waitlisted. But that is one segregated.
Valid for waitlisted. Where is that?
Kindly see, the page 142, top portion. 142, my lord.
What is the order you are facing?
Yes, my lord is saying that indisputably petitioner is not the waitlisted candidate. Panel is valid for my lord waitlisted candidate. My lord, this petitioner is impanel candidate, but the panel is valid for both, my lord, waitlisted and impanel. If the panel is not expired, but my lord is saying the panel is valid for the only waitlisted candidate. Well, I am the impanel candidate. But because my lord, kindly see the recommendation letter issued, my lord, kindly see the page 145, my lord, the notice for counseling.
Panel has expired in 2019.
But kindly see once, my lord, 145, my lord, page 145. Malad, kindly see, this is Malad, once Malad, I have lost my job, so that Malad, I am trying to Malad, kindly 145, this is the counseling notice मतलब 14th October 2022. But that is this is the impanel candidate. This is also one of the panel candidate. They have issued the recommendation, the page 202. Their recommendation letter, kindly see 10th 11/2022.
This supernumerary process
This selection process is challenged.
deprecated by the Supreme Court.
This is the Supreme Court is said, they have government had the power to create the supernumerary post. And paragraph 47, if they lost their job, they have accommodated by creating the supernumerary post.
That has been done by the Supreme Court.
No, that is not. Kindly see page.
No. While Alec Trent is making a total mess of the entire fact.
What mess up?
He is jumbling up everything. Supreme Court was hearing 9, 10, 11, 12, Group C, Group D. Supreme Court was not hearing upper primary, work education, physical education. So let us not confuse ourselves with the facts of Supreme Court.
Because in panel for upper primary.
Upper primary, work education, physical education. That is different from the main upper primary, which your lordships have heard.
Was in the panel of physical education.
Very well. Taking that, he was recommended, but he did not join.
Was recommended?
Yes.
He was recommended, he did not join.
Because he was working in
Yes. So the panel expired subsequently in 2019. So that is the end of the chapter as far as the petitioner is concerned.
Why the court says that this panel expired for weightlifting?
No, technically waitlisted candidates, because panel gets exhausted, part of the waitlisted also gets exhausted.
The date on which the panel expired, your entire thing has gone.
Yes, it was over. It was over until 2022, when the government took up a policy decision to create supernumerary post for the leftover waitlisted candidates. That is a totally separate issue, which is also under challenge.
145 says, in pursuance of such and such, government of West Bengal filling up supernumerary assistant teachers, including petitioner working.
Filling up of supernumerary post of assistant teachers, including physical education and work education, etc., in recognized aided sponsored schools. It is hereby notified that the counseling process for the assistant teachers of work education and physical education from the waitlisted candidates of the first SLST, first state level selection test for recruitment of assistant teachers, upper primary level physical education and work education 2016 shall commence.
What happened after that?
Then the recommendations were all complete. The entire waitlisted, yes, entire waitlisted, all are recommended. Not a single one is left out yet. But the appointments got stayed by the Honorable Single Judge. That matter is being heard out. The notification of 2022 by which the supernumerary posts were created, that is the under challenge. That whether the state has the power to create supernumerary posts in this.
Those waitlisted candidates have already been
Recommended. All complete, only appointment.
Mr. Chaudhary, you have a bad case.
But
DC score or
after vacation. Because the affidavit, the writ petition, I made a representation before the author.
But we have to get something to help you.
I have made the representation by considering the paragraph. If the other same similar circumstances, the learned honorable single bench,
But not seeing the obvious.
My
Know the obvious.
yes, my prayer before the honorable single bench is that representation should be.
That ought to have been the wait list to come under this 2020 circular.
But this is
But not a wait listed panel.
They did not.
Panel, yes, your destiny was wrong because you continued in that exams, that tainted process. Because at that juncture, you also had no knowledge.
My lord,
that in 2023, my appointment will go.
My lord,
Understand? But
my-
how to help you?
my lord, because my lord, the in previous service,
Previously you were not working as a upper primary physical education or work education.
but similar issue.
And election was government's Supreme Court said that had they been working in other posts, say in Panchayat department, then the government will make an endeavor to see he gets into that because you have lost your. But in this case,
My lord, subject to lordship, my lord. My lord, as per paragraph 47, my lord, we are similarly situated, my lord, in upper primary and the physical education work education. My lord, in one selection process, my lord, they are getting the my lord, counseling order from the, my lord, the honorable court. But in my case, my lord, I am not been permitted to, my lord, my lord, one, my lord, kindly let them decide it.
So the item number 12 and 13 have been directed to be listed along with item number 11.
It's a big matter.
No, not. But, my lord's order dated 9th September. My lord directed that item number 12 and 13 would appear along with item number 11.
So it is appearing.
Yes, yes. Now, in item number 12 and 13, my lord, there is an interim order.
It is expiring when?
No, there is an interim order against which we have come up against the interim order. The appellant is seeking blood time. They are enjoying an interim order. I have come up against that interim order, whereby the writ has been held to be maintainable against the DA getting school. Now, if this interim order remains, my school is in financial doldrums. The other teachers would approach during the vacation which the school.
Hear it out on the video.
Kindly fix a date. Kindly fix a date.
Immediately after reopening, no.
Tell us which date.
The 28th is subject to my lord's kind sanction.
এই থাকবো না আমি না থাকলে আমি বললাম
কবে তুমি বলো তাহলে একটা ডেট
তাহলে 14 তারিখ করলে নভেম্বর আমি যে থাকবো না আমি আই উইল বি আউট অফ স্টেশন ঠিক আছে
Yes.
ঠিক আছে
Not a formal order be recorded.
Here record
একটা অর্ডার হলো
Mr. Badi,
11 I'm for the writ petitioner respondent
11.
11 for the state wallet.
I'm 12 for the state.
So, today an adjournment but on behalf of the
14, my lord, I am for the writ petition respondent. Dr. Patru is the appellant. To substance. করবে না, করবে না?
There was a direction upon my learned friend to take instruction.
Yes.
After vacation. Yes, 1 week after vacation. Next.
I
Let it be on
definitely
10.
require a
Let it
stay.
be on 10.
The
10th your
opening
lordship.
date 24th, my lord has already. Oh, থাকবেন না।
10th November.
10th. Then 14 and 15th, 15, both are together. Yes, both are together. Rajiv? 16 আমি আছি তোর সঙ্গে।
আবার কি করবে?
পাগলামি করছিস না?
Yes, my lord, I am for
লিফটটা দে আর চিকেন লিফটের ওই লিফটটা দে।
I am for that.
না, চিরঞ্জিত পাত্র।
No.
Both the restriction application was made.
My lord, Rinki Poddar recommendation, my lord, Rinki Poddar's recommendation on 23rd of December 2024, and where Rinki Poddar applied for extension on 7th April 2025, beyond 90 days. My lord, beyond 90 days, and my lord, recommendation has been extended by the authority without any reason, just simple by a resolution, by a meeting conducted, and we have extended the same. My lord, I am giving the detail of Rinki Poddar.
Bring that on record. That is on record.
No.
Then Dr. Patru
is
your instruction.
My lord, Rinki Poddar is a totally different case. Totally different case. It is a case of re-recommendation. It is not a case of extension of recommendation letter. The candidate was recommended. The candidate could not join due to medical reasons. The recommendation was extended. Still, she could not join due to the vacancy was not matching. So we re-recommended her in a different school. That is not extension of the recommendation letter. It is a case of re-recommendation.
So your original recommendation made in favor of Rinki would not be given effect.
Yes, because the vacancy was defective.
Vacancy. So you extended. So you.
No, we initially extended so that she could go and join. When she went to join after the extension, then it transpired that the recommendation, the vacancy is not matching the candidate. The school did not allow joining. She came back and we re-recommended, and that is.
But initial recommendation was extended.
Yes, but this order does not show whether the application was made within 90 days or not.
Yes, my lord, I am giving the detail.
That's what he's saying. That is why we checked up.
Yes.
That did he apply beyond 90 days? Or we told
Beyond.
you to take instruction and come.
Yes, I have given the copy.
No.
Given-
I took instruction with regard to Rinki.
We understand that ultimately the end result had to be,
Yes,
but the original recommendation was extended for whatever reasons.
yes.
Then how can you being a statutory authority take a different step? Talk
Fine.
with your chairman.
Very well. I will just check whether the.
Done that.
Very well. Let me come back on the reopening then, because that instruction I require. Whether that gap was beyond the 90 days.
Procedural
Well, for the applicant in this one.
Again, transfer matter.
Last, before vacation, the last one.
Last for all times.
No, before vacation, this vacation. I would request your lordship to take the impugned order once. Is though regarding the single subject teacher, only one paragraph is troubling us. Paragraph 15 of the impugned order. Kindly.
Where is this 26th August?
That I handed over last occasion. It is in your lordship's records.
Tell us what has
Yes. Kindly take the impugned order, paragraph 15. I will not trouble your lordship with the whole order. Now the single subject teacher, the willing word has been withdrawn, but now it comes in with another rider. In the event teacher is found from neighboring school, immediately steps shall be taken for transfer of the petitioner in terms of government notification dated 3rd January 2022. Now it becomes conditional. In the event, if the teacher is found, then only he will be allowed. Now the 3rd January notification nowhere says that this rider has to be given. It is given in the event application is made, then that is to be considered. Not that in the event teacher is found, then only it will be allowed. Now what happened, my lord? I draw your lordship's attention to 2 previous orders. My lord, your lordship. My lord, I made application in 2022. My application is pending. Application also.
Which page?
Yes. That is at page number 175. Sorry, 175.
Mr. Acharya, kindly come to the
Last paragraph.
now, penalty method. Now in quantity examination, such and such following guideline. are issued to take care of transfer application of the above. In that event, a single teacher makes application for transfer, the school will not reject it and inform the DI. Now the DI's function start. DI will immediately discuss the matter with the commissioner in what is the word?
That is as
Malan,
well.
this is a typed copy.
Type,
Malan,
there are
previous
some
copy
mistake.
174.
There are some mistake.
বলছি তো 174 is the original copy.
In the event a single teacher makes application for transfer, discuss the matter with the CSE and make local arrangement.
That is not there, my lord.
Hmm?
Discuss the matter with the CSE, full stop.
Acha,
In
stop.
fit cases, the DIAC will take urgent step in time-bound manner to search
Where
for
you
a
are reading, Mr. Mondra?
My lord, this is the ভুল আছে এটা।
না না তুমি
My lord, this is the
You have a clear copy?
দাও না দাও।
my lord, fresh copy, my lord.
No, no, you don't have copy. No,
Actually, your lordship is reading the typed copy. There is mistake.
no, you read. Then you
Very well, my
read.
lord. My lord, I am reading, my lord. My lord, from the
I will immediately discuss with the commission.
discuss the matter with my lord, the CSE.
Hmm.
Then, my lord, in fit cases,
Yeah,
the
yeah.
DI
In fit cases. Acha.
the DI will take urgent step in time-bound manner
So first duty of the DI is to discuss with the
with CSE
second duty is to take an urgent step in a time-bound manner
to search for a teacher on the same subject from nearby schools and make local arrangement so that the teacher of the other school attends the school wherefrom the teacher concerned has applied for transfer on limited days of the week on a temporary basis.
So let us stop here. So he will make a local arrangement.
Yes.
Where is local arrangement is not defined under the guideline.
No.
So when it is not defined, you are saying that this local arrangement presupposes the presence of a teacher who is willing to join.
Yes.
Presupposes. So the DI will make a local arrangement. It is not permissible upon the DI that he will not take any one of the teachers, whether they are willing or they are not willing. He will issue a memo. Unless this is done in West Bengal, this transfer issue will never come into a fit case.
But
Numerous appeals will be filed and the division bench will consider us. Then the learned single judge will say something which will be pointed out by the advocate that see, this is again in violation of the issue. We must end, na? Suffering should end. Time to should come. So why did we say so? Local arrangement, first of all, is not subject to any rider of any willingness. That is not.
That your lordship has decided.
Now attention, where from has it done? Now next line, please read.
My lord, limited days of the week on a temporary basis till such time a permanent teacher on that subject joins.
Now
Very good.
next.
Now, my lord, the DI will inform such arrangement to the CSE.
Then if the DI has to make an arrangement, then he has to inform it to the director.
CSE after making the arrangement. After making the arrangement.
After making it. So this arrangement, DI has to take a call. Then let the DI say that I cannot make any local arrangement unless there is a willing teacher. We will appropriately deal with that.
But for as my learned senior friend,
I have, my lord,
there is no teacher available.
My lord,
In that
circular
subject.
never says, my lord, that you take a teacher from a particular school and this school maybe, if he is not, my lord, if there is no
In a
local
fit
arrangement.
case, in a fit case,
In a fit case.
in a fit case, you will do it.
Then, my lord, it has to be, my lord, your lordship is correctly pointed out, it has to be discussed with the CS. My lord, that I must say, my lord, That has not been done.
Then the DI has to take that it is not a fit case. Why? For I cannot make the local arrangement because there is no such teacher.
Yes,
If there is no such teacher, there is no problem. But if there is a teacher, but who is not willing to come, order has to be passed by the DI. That I issue the order, you please come and take
discussion with the CSC.
whatever you then
Your
it has
Lordship,
problem
kindly
has to be
take it up after vacation. I shall talk to the DI and my lord, forward all the papers to the CSC. Have a call with the CSC, my lord. Then my lord.
Otherwise, Mr. Acharya, innumerable appeals and
Yes, yes.
petitions.
My lord, you on the other, my lord, we have to see, my lord, the other side of the coin. Suppose, my lord, DI issue a memo directing me X to join this school. Then say he will come, he will challenge this. Then the multiplicity.
Law will take its course.
Therefore,
will take
my
its
lord,
course.
kindly let the matter be taken up, my lord, after some after vacation. I shall talk with the CSC and the DI also. What is your lordship falling from your lordship? I shall convey this. That much, my lord, kindly. Then your lordship direct the DI to take a teacher from a particular school.
Why should we direct? Government has told him that you do this. Local arrangement is not to be made by the High Court. Local arrangement, Mr. Acharya, you are appearing for the DI, you are our officer.
Yes, yes. No,
So,
doubt.
Mr. Acharya, you have to convince your DI.
No, whatever, my lord, I am, my lord, the creature of the instruction. Whatever
Exactly,
instruction comes to the
exactly.
DI,
Now,
I have submitted.
no. DI has to be told that what the affidavit which you will file, you highlight on this issue so that now you can make an argument. Otherwise, what?
My lord, may I just make one submission regarding this fit case? My lord, I am addressing that issue specifically as your lordship has read it, that in fit cases, not finding a teacher is a fit case. Possibly that is not. I subject to correction. The notification says in fit cases, fit case presupposes the arrangement. Now, what is the fitness? Fitness is not regarding finding a teacher in a nearby school. Fitness is whether I have completed 5 years continuous service, whether there is any judicial proceeding.
Then, Mr. Lady,
So that
we have
is
to
not
decide.
fitness.
So we have to decide the issue then.
Yes, only one thing, my lord.
Setting aside and remanding will not serve any
That's
purpose.
I'm trying to appreciate. I'm making for appreciation of your lordship. Kindly appreciate this of 2022 application. Before this letter, there was another letter in 2024 with the same wording that I'm sending to the schools. It is a part of the writ petition that I'm sending to the schools. Schools must come with the teachers. Then it has happened earlier also. This is just a repetition. Now that has been addressed by Gokul Chandra. That is why I was trying to appreciate place before lordship.
I have seen that judgment.
Paragraph 10 and 11, Gokul Chandra clearly says
it is high time, Mr. Lady, we have to return an appropriate finding.
Yes, I just request your lordship to take
does
one.
not come like a shuttlecock. Single judge will say this, appeal will set it aside.
I know that.
DI will again pass that order.
Not very convenient for me also. Not very embarrassing for me also at times. My lord, kindly appreciate Gokul Chandra has.
You have to substantively argue this before the learned single judge.
I have tried, my lord. Possibly I could not pursue.
No, some case it has to be said. What does it mean? His lordship's order becomes ineffective.
That is why I have come, my lord. Gokul Chandra clearly says, kindly take para 10 and 11 for once, my lord, for my satisfaction. It says.
We have seen that.
Yes, it says that It cannot be kept pending for till eternity, and this cannot go on round and round and round. That has been observed in paragraph 10 and 11. Categorically mandatory direction upon the DI that it is you are mandated to do it. That is why I have come.
Ashok, the present appeal has been
The
preferred.
subsequent.
You file, you
No,
tell
no, no,
us,
Malad,
we
here,
will
Malad.
decide the issue.
No, no, there are other
Your commission also, let them come.
commission. It has not reached to the commission. It's happening since 2022. For 3 years, the same letters are coming every
Appeal has
time.
been preferred, challenging, order dated. দেখে নিন। Yes.
My lord, I am appearing for the college service commission respondent, my lord.
That I
in
appear
this
for
matter,
the appellant's petitioners.
led by Mr. Panda, my lord. My lord, difficulty, my lord, they have not served any court.
My lord, it's been served as the affidavit of service.
My lord, only, my lord,
My lord,
only,
my lord, even then I'm willing to serve a copy right now. Another.
my lord, only through mail, my lord, no hard copy.
My lord, nowadays that's
Yes.
affidavit of service.
Let us.
My lord, may I hand over the affidavit of service?
Order was passed on 2nd September. Petitioners.
What is the issue involved?
My lord, the issue involved is lordship.
You are again there in this matter. You are there.
Writ petitioner.
My lord, the appellants are the principal and the secretary of Ramakrishna Mission Residential College, Narendrapur. It's one of the top ranked colleges in the country, and lordship knows that it's run by the Ramakrishna Mission, which enjoys a fundamental right under Article 26 of the Constitution, where a religious organization can run an institution espousing its religious beliefs. Now, lordship knows that any recommendation made by a college service commission in respect of any government, non-government college is not binding on the governing body of that college. The recommendation goes to the governing body considers it, it may accept the recommendation, it may not accept the recommendation, and that is not justiciable. No mandamus can be issued, and that is a settled position, lordship, from the Supreme Court as also by the division bench of this honorable court. Now, we have the judgments, my lords. Now, what happened in this case, lordship, it has never happened before. I may indicate such an instance has never happened before, where a recommendation has come and this particular institution has not accepted. It has always accepted. In this case, lordship, it's an extraordinary case where the recommendation was made of a person who, when the governing body sat to ratify the decision, my lord, came across several public posts whereby for several years, this person has had a very public and vocal view, which is not only against other religions, which runs contrary to the fundamental belief of this particular organization, but also several defamatory, malicious, insulting, abusive, obscene, vulgar comments on public platforms, made in a manner so that it gives maximum publicity. Now, lordship, it went to the core of the issue. The governing body took a unanimous decision, taking the views of all its teachers and other stakeholders, that such a person would not be conducive to be teaching in this particular college. Because not only is his views not, my lord, it's one thing to have a different ideology, which is welcome as far as this organization is concerned. But what is not welcome is the kind of the slander, the defamatory comments, the vulgar, abusive comments, etc. Now, lordship, in view of that, an extraordinary decision was made to respectfully not accept this recommendation. So the college response was given to the College Service Commission, annexing those particular public posts, saying that we have nothing against this particular person. He may be sent to any other college, but kindly excuse us from accepting this person, because not only is it violating our fundamental rights, but it is so fundamentally opposed to every single thing that this organization believes in that we are unable to have this person as a full-time teacher. Now, lordship, the writ petitioner, the teacher involved, filed a writ petition. We raised the challenge of maintainability, saying that a recommendation of the College Service Commission cannot be enforced through a writ of mandamus, and we placed the judgments. Well, initially what happened when the matter went before the first bench, the learned judge inquired from the College Service Commission and passed a direction that they look for avenues to accommodate this person in any other institution. Now, we were given the opportunity of filing an affidavit.
After your governing body resolution?
After challenging that resolution, challenging our refusal to...
Commission wanted to place him in any other vacancy?
No, lordship. Directly after that, the writ petition was filed. This inquiry was made from the learned single judge as to whether he can be accommodated. Right. In the meantime, affidavit directions were sought to be given. In view of the fact that
If was the recommendation made?
Well, the recommendation was made in 29 December 2024. 2023, I'm sorry, Lordship, 2023. Writ petition was filed, I believe, in 27 February 24.
Maintainability point was answered.
Lordship, it was, all these points were kept open. In fact, in the interest of the petitioner, the first court did not record many of these issues, but I believe the maintainability point was kept open. We were asked to file an affidavit. At that juncture, Lordship, we indicated to the Honorable Court that if we are to annex all those posts with our affidavit, it may prejudice the petitioner. So a suggestion was made by the Honorable Judge himself that you can always crave leave. So we made this averment in the affidavit and craved leave to place those documents if at all required, because we had nothing to do. We did not take any stand prejudicial to the petitioner because we have nothing against the petitioner. However, Lordship, thereafter the bench changed. When it went before we filed our affidavits in the meantime, when it came before the new bench for hearing, the commission took a stand that no, our recommendation is binding on the college and that we will not place this person in any other college. In fact, that is recorded in the impugned judgment as well. And the petitioner also argued that his writ petition be allowed. Lordship, we made our submissions both on the aspect of maintainability by placing the judgments of this division bench, of our division bench, following the Honorable Supreme Court. And we also argued that since a recommendation is not binding, and since we are a religious organization, even though, Lordship, the Supreme Court has held that Ramakrishna Mission is not a minority organization, it can't claim minority status. But what it can claim is freedom under Article 26, being a religious organization, to run its educational institutions as per its religious beliefs.
In the writ petition, any interim order was
Interim order was not passed because the learned single judge, which the concerned court which took up the matter at the first instance, was of the prima facie view that perhaps the writ petition is not maintainable. However, we chose to not take a stand against the petitioner and said that if through this court, the petitioner can be placed in another college, we don't have a problem. And that has been our stand throughout. It's there in our affidavit. We submitted that during the course of arguments, and that's recorded in the impugned judgment. Now give this process. Prayer for today is because there are important issues to be decided, and there are issues of large-scale ramification involved as to the rights of an educational institution run by a religious organization under Article 26. Well, I'm only praying for, by the order of 2nd September, Lordship, the person has been directed to be given appointment within next Tuesday. I'm only praying for a stay till reopening. Lordship fixes any date. I'm ready to argue even now, but I understand, Lordship, there may be paucity of time because you are closing for vacations. Lordship may kindly give us that protection till reopening. But I may indicate one thing before your Lordship's concern.
Any contempt application preferred?
No, because we have time till next Tuesday.
That time is yet to come, my lord. On Tuesday, 2nd October, my lord, the
30th.
time period will open.
It is still 2nd.
Yes,
Malad, it's still
that is why it
30th
is not
September
possible.
as per our understanding. It's 30th September because 4 weeks from 2nd September. That's the
30th September, 4 weeks will be over.
Lordship. Malad, may I place just one thing before that, Lordship? One document I want to place.
Within a period of 4 weeks from the receipt of the copy of this order, page 251.
Malad, because we were there when the order was pronounced, we can't really take that plea.
Page 251. And after that order, after getting my lord the server copy, and I think my lord this cause of action will arise after 2nd October. Second, that is why my lord our humble prayer before this order, this is not so early.
I have another ground for seeking an urgent prayer, Lordship. May I just place that? Lordship will grant me just 2 more minutes. My lord, by the impugned judgment, it is acknowledged by the learned single judge that the recommendation is not binding. During the hearing, we had handed over all the posts, but his lordship refused to consider them and has recorded in the impugned judgment that these posts have not been placed on record. We showed the pleading relating to craving leave, but his
Post
lord
means your institution.
no,
somewhere
the public posts made by the writ petitioner, which will show what his views are, on the ground of which we rejected the recommendation. Lordship, the posts, the public posts. Now, lordship.
Well, it cannot be, my lord, because in affidavit they did not disclose all these documents.
No, we crave leave, we showed that. We placed it in the hearing.
They are not free for a
Crave reference.
No, I think to understand, my lord, any paragraph where they said, while not free.
You will point out, Mr.
Page
142.
My lord, will kindly see page 142 of my affidavit.
Paragraph D of the stay application.
Page 142.
42, lordship.
How long?
My lord, D.
Paragraph D.
But I've seen it. Now just I've seen, but
You are saying there's no such pleading.
My lord, even in the post in the, my lord, the Facebook, we can stand on the way. And my lord,
No, that's a ground for not accepting the recommendation.
it cannot be, my lord, subject to, my lord.
That's a submission.
No, my lord, may I please one thing now? Lordship, this has been held that it's not on record. So, learned single judge holds that I have not seen these posts, but it was not justified on the part of this college to refuse the recommendation. Now, I ask myself, Lordship, this question, my lord, without perusing the posts or considering the same, how could an opinion be formed as to whether the refusal to accept was justified or unjustified? Lordship, now what has happened? My lord, the second ground was an undertaking was given by the petitioner, which is recorded in the impugned judgment, that no such posts, no such comments will be made henceforth. On that ground, the court below held that in view of such assurance, appointment may be given. If any such views are made, then appropriate action may be taken. Now, I'm just showing one.
Court has said in the order.
It is there in the impugned judgment. In view of such assurance, may show that for paragraph 50 of the impugned judgment.
At page 250.
Lordship will kindly see page 250. Paragraph 50, Lordship will see at page 250. In response to my query, Mr. Chakraborty has assured that the petitioner shall not make any comments against the ideology of Ramakrishna Mission in public. In view of this assurance, I am of the opinion the governing body ought not to entertain any apprehension that an individual like the petitioner may pose an imminent threat to the ideology of Ramakrishna Mission. Now, Lordship, I am placing, Lordship, one out of several posts made by the petitioner and his wife, posts by his wife where the petitioner has supported, posts by the petitioner where the wife has supported, and this is the most non-controversial post. Lordship will see the 2 pages. Well, I want to place this aloud.
No.
And some Lordship will see in the last paragraph on the first page.
Later.
Some aspersions against me and my learned friend. We argued the matter for the same. And Lordship, this is the one without expletives. All the other posts are far worse than this. And Lordship, statements have been made widely to the media. This has been widely reported. Lots of disparaging comments against this organization. And my clients have chosen to remain silent. And Lordship will see, my lord, one interesting formulation, a play on the word of the organization with creamy, which is worm. And other posts will say that they want to by coming to this organization, he wants to deworm this organization.
How did the single judge deal with this issue?
But
Because
the
he is
learned
not-
single, despite all these posts being placed before the honorable court, this has not been considered at all. In fact, the learned single judge has gone on the issue that if a person has a different ideology, that is no ground for refusing. But what, Malad, in most respectful submission, what was not considered by the honorable judge is that there's a difference between having a different ideology, being an atheist, and having a stance like this in public. Well, a difference in ideology and slander, defamation, abuse, vulgarity, they are not the same. This issue has not been considered by the learned single judge at all. It has not been considered because there's a clear finding that this is not on record. Lordship will see paragraph 44. And paragraph 45, Lordship.
Yes, where is your counsel?
My lord, he is
Why
there.
you are seeking adjournment?
My lord, they have not served any copy, my lord. Hard copy they have not served. My lord. Only notice intimate, my lord.
Who is your counsel?
My lord, Mr. Shubhranshu Panda, my lord.
Has been served on mail. Where is Mr. Panda?
But I believe he was here before
He is
before
My
lunch.
lord,
My lord, I'm giving anyway. Because there's an urgency. This is for the third time I'm serving, but I'm still serving another copy.
no, my lord, the only server copy, my lord.
Sir, kindly come to page 250, paragraph 49. As noted earlier, the commission that recommendation for any post
Where you are reading?
250, my lord. The order, paragraph 49.
49.
Yes, my lord.
Well, he is not in my lord court. He is leave, my lord.
But it also
Just now taking this, kindly.
Would be affected if interim order is done. Mr. Chakraborty would be affected.
My lord.
If any interim order is passed, he would be affected.
My lord. My lord.
We will record your presence.
My lord.
But since
The problem is we could have also not, because we are seeing that it will fall within the vacation. your date for joining.
Lordship. But this is true. At the same time, no contempt application is there.
But Mr. Chakraborty,
But there is no scope to file contempt application since division bench is there, my lord. When, my lord, the appeal is preferred, my lord, definitely, my lord, everyone must be slow. That is the principle laid down by this honorable court on different occasion.
that
So
you
after
may-
reopening, my lord, kindly fix this matter here and then, my lord, pass order. Because of, my lord, one document I'm at the same breath I'm showing while rejecting myself, what was their, my lord, stand. Thereafter, my lord, lordship, kindly come to page 106 for a while, my lord, for my satisfaction, my lord. Here, my lord, they have not taken this public post. My lord,
don't approach for
no,
appointment.
well, certainly not, because of division bench is there, my lord. After vacation, immediately after reopening, kindly, my lord, fix a date.
We will record that.
Yes, my lord. At the same time, only one document, kindly see, my lord, what my learned friend is trying to say.
Well,
that is beyond pleading.
Post that I placed, that's the most harmless post coming out every day from the petitioner and his wife's account. Lordship, we need some protection.
Yes, we will record his submission on instruction that he would not be approaching you for appointment.
And Lordship, this the comments being made about the learned single judge's judgment about how no proof, my lord, every public trial is going on. A media trial at the instance of the writ petitioner is going on.
At the same time, my lord, I will show.
And Lordship, this, my lord, some protection on that.
But at the same time, I will
we
show.
all are left
My lord,
exposed.
threatening even to the honorable court.
Protection you want.
I will show, my lord.
The protection you are wanting is that you may face contempt.
No, it's not about contempt, Lordship. It's
Contempt
the public trial. It's the public trial which is going on against my clients.
We will record.
The trial is going on against the judge also. I will show, my lord.
We will record Mr. Chakraborty's statement
Lordship.
that he submitted before us on instruction that he would not be approaching the college for appointment.
Grateful, Lordship.
Yes, my lord.
Grateful.
May I read only one post against the judge, honorable judge, in the public domain? He is quoting each and everything. If everything is sponsored by me, then this is sponsored by them. After the judgment,
My clients are the most vulnerable creatures. We cannot speak out.
even, my lord, how dare the judge is.
The problem.
This is the problem, my lord.
The problem. Suppose today you say something.
In public domain.
Suppose if I say anything against you, before saying that I should give you an opportunity. Yes, Mr. Chakraborty, why you are doing this?
Grateful.
Here, my lord, the post is how dare the judge is.
Ultimately, it is the detriments are being suffered by this post, which are arguably, if it has been made. Suppose you are not a non-believer.
Yes, my lord. My lord, this is, my lord, from a page of Dr. Tamal Das Gupta. Other persons are also there.
Where will this antagonism end? Tell us.
One thing, my lord. At the same time, is it a criminal offense? Is it not permissible?
No, Mr. Chakraborty, you are a teacher.
My lord.
You have certain ideas.
Yes.
We also have certain personal ideas. So if once we start making comments, or if your body language is such, because it is an educational institute.
True, my lord, definitely.
So today, suppose we hold in your favor.
And I am eager to join there.
Exactly.
But kindly see 106 page, one page, my lord. After, my lord, this refusal, this post is, my lord, generated. My lord, kindly see 106 for a while. Second may kindly be spared. Second may kindly be spared.
106.
106.
25th January.
Yes.
That's not a post, that's a letter.
No, later, at that point of time, what was the stand of RKM? Ramakrishna Mission. We herein received a recommendation letter from, I am skipping. In a matter of regret, however, that on the second day of our meeting, there was unnecessary aggression on your part, second meeting, while interacting with the Secretary Maharaj and me, and we were charged or not issuing the letter of appointment. Be that as it may, we regret to inform you that we are unable to accept the recommendation of your name by WBCSC for the post of Assistant Professor in English, and have accordingly informed the WBCSC. We are therefore unable to issue the letter of appointment. This was my lord. This was the stand taken by them at the outset. After the refusal, my lord, I am an associate professor in Delhi University. I have sold out my flat. Everything I have decided to come back for my family and all these things. Maybe I have made some comments and they are using that comments.
Mr. Chakraborty, we will hear it. Don't make any further post. But make any further post.
Lords, at the same time, the post which are, my lord, generated against the judge also, my lord, honorable court also, that is required to be stopped. I will show.
How can we go into the social?
So that is why, my lord, that question, if he,
as we are recording your statement.
yes, my lord.
Say that you, upon instruction, you are saying that.
Yes, I am not approaching. I will not
approach.
Yes,
The school, you will not file contempt.
Yes.
Let the matter be
Yes,
finally
madam.
heard
Yes,
on a
madam. Yes,
particular.
madam. Very no.
And you will also say that you will not be making any.
Well, this
further
is, my lord, I am most humbly and respectfully submitting, my lord. I will advise my client, but at the same time, my lord, don't make such observation by this honorable court. Whether this, my lord, this offense, my lord, my right to, my lord, and all this right enshrined in the different article. And this is not their prayer. Documents
Both sides are not throwing it.
Yes, I'll show.
Mr. Chakraborty, you are first award officer. Mr. Sarkar is
Yes,
also.
yes, yes, madam.
We have not heard the matter. True. But due to this vacation, we are having this problem.
Kindly keep it after the immediately after.
But in the meantime, you are right.
Yes,
Suppose you record your instruction that don't make any post.
Yes, madam.
If your client makes any post,
Then it will be detrimental and prejudicial.
you will be defamed.
Yes,
but we will see the development if on the date we are fixing. If further posts are being circulated,
They are at the limit. I'll request him, my lord, not to do anything. That may not be written, my lord.
Is he in court or he has left the court?
He
was here?
No, my lord.
Hey,
Appellants,
any urgency?
yes, my lord. Regarding the upper primary, today is the last date of the life of the panel, my lord.
It won't be the last date because we have already asked them to sit with the government for adjustment of the vacancies. We
All
have
right.
passed an order in contempt. You were there. You were there?
No, no, no.
I was with Justice Partha Chatterjee.
But here the petitioners participate.
There we did not grant any order as regards the panel. We said that we have, if the panel expired, then how can they sit with the government and adjust it? So you need not be worried, I think.
Let me place the case, my lord. The petitioners participated in the first SLST 2016, both in 9, 10, 11, 12 as well as the upper primary level.
কমিশন নেই তো, কমিশন কোথায়?
The appellants participated in the first SLST 2016, both 9, 10, 11, 12 as well as the upper primary level. They are selected in the 9, 10, 11, 12. Their appointment, they are recommended. They were serving the respective posts.
It did the same order came to us.
After the judgment of the High Court as well as the Supreme Court, they have lost their jobs.
No, your job has been continued till December. You are not in that group.
No. No, that is there, my lord. Not.
And you have not participated in the fresh selection process?
Participated. No, they have participated. They have participated. Now, what happened, my lord?
Then what happened,
Now, my lord,
Mr. Wari?
what happened, my lord? Here, they are also successful in the upper primary level. Now, my lord, for two reasons, my lord, they did not participate in the personality test. First of all, they are serving in the higher post, 9, 10, 11, 12. First,
personality test was much earlier.
Yes, my lord. Since they are in service, my lord, they did not participate in the personality test. And also there is a restrictive clause, my lord, who are serving in a higher post, they cannot participate in the personality test. For that reason, I participate. Now, after losing their jobs, they have made
No, there is no, that bar will not apply. Because you would be leaving that service and joining.
Yes, my lord. Now, what happened, my lord? That here the appellant's score is much higher without adding the personality test marks than the person selected or appointed. So even if I do not participate, these appellants do not participate in the personality test, they are coming within the zone of consideration without adding the personality test marks.
But without personality test, you cannot be appointed. That is the statute. Provision test.
Perhaps there is.
Which way you will enter?
Perhaps there is
ways
no.
are blocked.
Perhaps subject to correction, there is no such bar that if I do not participate in the personality test, my candidature.
Can you make that argument today, Mr. Buddy?
Kindly consider that aspect since they have lost their jobs.
Exactly, same matter came as before. We have said we understand your job has gone, but at this time the entire thing cannot be made topsy-turvy. You are saying that there are vacancies which would be adjusted for filling up.
Yes, my lord. I am not praying for disturbance of those selected candidates. There is existing vacancies, my lord, but they can accommodate the petitioners, the appellants hearing.
No, after our judgment which was delivered, you are falling within this 15,000 persons who were directed to be considered for appointment in upper primary.
No, my lord. Not that.
You are physical education.
No, no, not physical education. My lord, whatever appointments they have given, my lord, we are not claiming for
Not that
that.
appointment.
But
oh, you were not there within 15,000 also. Upper primary 2016, we delivered the final judgment saying that 15,000 persons, they have to be given, considered for appointment, personality test, and that they have done. Are you coming within that?
my lord, before personality test, the whatever the merit list was published after the written test, but we were within the
Show us that were you there in the panel? Where are you coming within 15,000?
Malad, no, Malad, our name was not reflected in the panel because we do not participate in the personality test. Our name was initial merit list. Our name was there in the initial merit list before the personality test. Before personality
that is the list which is prepared.
Yes, Malad. List which is prepared for personality test. There, Malad, our name was there.
Where is the commission?
Malad, we serve Malad.
There is no ground. It is dismissal, sir.
Malad, let
does not participate personal test.
kind of Malad. But my specific case is Malad, even if Malad without Malad adding the personality test, they are coming with the
That will be agitated now, Mr. Bhatti.
because the change circumstances, my lord.
Like
Because the change circumstances, my lordship, my lord, without disturbing anybody's appointment. This is the change circumstances. That's why I'm exiting this flat.
We can stay the dismissal till the yoga. More than that, we cannot do. Mr. Heard Mr. Bhatti.
The court is muted.
We don't want to speak, Mr. Yes,
but we would like to hear you.
Which matter you are appearing, Mr.
Item 20, item 20. Mr. Bikram Banerjee is there with me.
Any urgency?
The urgency, my lord, the fact remains, my lord, there is a.
So we keep it on 27th.
My lord, in the meantime,
Come after the vacation.
Meantime, my lord, the appointment notification should not be given by the by the West Bengal Board of Primary.
What appointment notification?
So what has happened, my lord? There were wrong questions. We have challenged date 2022 questions. Now, expert committee, my lord, division bench has directed. The report is still pending, my lord. We have just come up before your lordship to provide us with the copy of the expert committee report. This is our prayer.
You are there.
But for the appellant, to the disposed of appeal, my lord, they have filed the application, my lord, by Mr. So, my lord, today, my lord, are absent, my lord. Mr. Gupta.
So Bhattacharya, we keep it on the reopening date. Mr. Sharnal is not here, they are saying.
Lordship, we can keep it not on the reopening date or day after?
Tell us, Mr. Bhattacharya.
Monday.
Monday.
Any date, Monday.
In the meantime, if they start appointment, my lord, that will be
So then, my lord, we
for
will be
us.
prejudiced, my lord. If my lord a
Because we are,
directive
my
is
lord,
given, my lord, to submit the report, my lord, or else, my lord, it will be a never-ending process, my lord.
Disposed of appeal, what?
my lord, the
Mr. We have told Mr. Bhattacharya. Yes, 27th.
my lord, in the meanwhile, if they give the notification for the selection, my lord, our right will go, my lord. We are date 2022, my lord.
What right will go? First you have called for question papers. Answer will be.
No, my lord, we got it, my lord. Date 2022, there are several wrong questions answered, my lord. We attempted that, my lord.
Though Shamim, he is not there. We are not with instruction. We are keeping on 27. If anything
So
happens,
1 month is vacation, my lord. But during that vacation period, if they not give the selection notification, my lord, that will otherwise, my lord, our right will be prejudiced, my
without
lord.
hearing the matter, can we do? Come on 27, Mr. Bhattacharya would be there.
Yes, yes, my lord.
Yes, next.
Primary School Council, my lord.
For the appellant. Kindly see, my lord, this is for the appellant. I do not know, my lord, this is the order. My lord,
The order?
either, my lord, review has to be done, or, my lord, I do not know, my lord, what, my lord, I have not served also, my lord, any application.
Not served.
Not served.
2024 appeal. You are for
It-
whom?
I'm for the, my lord, board.
It is.
And Mr. Saha, you are for the appellates.
No, my lord. I am for the district primary school council.
Who is for the appellate?
Every Mr. Bari is appearing.
No, 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 Badidar.
Mr. Badi is here.
No, no, Badidar.
এত মামলা থাকলে
22 নেই 22 না
না না বাড়িদা নয় এটা
না না তো না ও
no, no, no.
সরি ঠিক আছে
মাথা খারাপ।
1 week after vacation.
কত আছে আপনার তো জানা
So লিস্টটা একবার কল করে দাও 1 week after.
Well, the
Oh, you will take it back.
no, my lord,
3.
also order তো আছে order.
1 week.
কি অর্ডারটা একটু দেখি
ডাকুন
24 I appear.
24, you are for the respondent.
For the appeal.
Appellant. Any urgency, Mr. Badi? Your service is complete.
Such urgent.
1 week after vacation. Next.
I am appearing for the Purva Bardhaman DPC.
20, item number 25, I'm praying for not today.
Same order.
27. Sorry, one. All are 1 week after vacation.
We are keeping it because again combined list will come. Again, if it gets disturbed, then there will be a problem.
In 26, my lord, I am appearing.
All right. No,
Mr. Bari is
you are making a
petition.
prayer.
No, no. Because immediately after vacation, I will not be available.
Which matter you are saying, Mr. Badi?
This 24, 26, 27, 28.
Yeah, 24, 26,
26,
27, 28.
28.
So we keep it
And
2 weeks
20
after
2 weeks
vacation.
2 weeks.
29 also.
Lordship.
29, 2 weeks after vacation.
In 26, I am appearing.
All right, Mr. Shah, we are simply adjourning.
Lordship, no need.
Yes, next. Where is it?
Please, after that.
31, my lord, I am for the petitioner, my lord.
Item number
Oh,
30.
that full service commission.
I am for the petitioner, 31, my lord.
Yes, yes.
Item number
Full service commission,
30.
90 days.
1 week after.
Yes, yes, yes. On the last occasion, Mr. Dr. Patra already concluded his hearing.
Now after vacation, Mr. Yes, not to
Well, I appear for item number 30.
30.
My lord.
Yes, we have kept it.
1 week after.
1 week after vacation.
36, my lord, I am for the petitioner. My lord.
Contempt, fresh application.
No, my lord, it has already been served, my lord, admitted by your lordships, my lord, served upon my lord the contemptor. On the last occasion, my lord, the state also appeared.
Whose order? Our order?
My lord, the block land and land reforms officer, my lord, is the contemptor, my lord.
Whose order? Whose order?
My lord.
Our order?
Yes, 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 yes. Your lordship, my lord, sitting with
I did.
Justice
Chatterjee.
Helumani.
Oh. What happened? That BLRO is not passing the order.
Passing the order. Called for hearing, my lord, number of times, not passing the order.
Dekhi dao. Anybody appeared for BLRO?
Yes, on the, my lord, during the writ petition, during my lord, the main application, my lord, Mr. Somnath Ganguly was there.
Contempt.
On the last occasion, my lord, a state appeared.
Somnath Ganguly, I think he has. Oh,
My lord, should I serve a notice on Mr. Ganguly and my lord come back tomorrow, my lord? My lord, can be disposed of, my lord, very, my lord.
what we will dispose of? If we dispose of, your order will not be passed.
That is also true. That is also true. That has been, my lord, on the last occasion, I've already faced that, my lord.
Dekhi dao. I took order.
My lord, page number 7, my lord.
এই এভিডেভিট সার্ভিসটা কোথায়?
Is upon the contemptor again, my lord.
You've already served.
Yes, yes, my lord. Every service.
We will issue the rule. What more?
You indicate the next date of hearing. If you
My
are
lord,
not
that
there,
I'll do.
You have got recent information after service. What happened?
No, after service, my lord, no further, my lord, date was communicated. Lastly, my lord, for hearing, he was called, my lord, in the month of July.
hearing concluded.
My lord, hearing, he goes to the hearing. My lord, the BLRO hears him for, my lord, 15 minutes, tells him that we will communicate to you. If it is concluded, then the proceeding is over. Otherwise, my lord, we will communicate to you the next day. This has been going on, my lord, for the last number of years. My lord, my lord, more than, my lord, 3 years this is going on.
That will be the ground. You will say it's not concluded. Hearing is going on. There's no order, no? That hearing is.
There's no order. There's no order at all.
The affidavit of service to be kept in the record, my lord. Some one line direction, my lord, that the matter was, otherwise, my lord, I'll tell you what, my lord. My lord, so that I can issue a note, my lord, another a service letter upon, my lord, the land. If that, my lord, opens up his eyes, my lord.
Affidavit of services file be kept on.
Grateful, my lord.
Yes, Mr. Das, any matter where both sides are here?
38, I am for the state respondent. I am keeping the maintainability. It is a appeal against the rule.
37 থেকে একটু ডেকে দাও। Then Mr. Das come after vacation.
I am rely upon the two judgment 2006 5 SCC and 2019 96 4.
কালকে লিস্টটা কি হবে একটু